Good afternoon, Chairman Wayne and members of the Judiciary Committee. I'm Megan Hunt, M-E-G-A-N-H-U-N-T, and I'm here to present LB89, a bill about removing barriers for Nebraskans who want to start or grow their families. Over the summer, I was meeting with a constituent who mentioned that because of current statute, Nebraska is considered a surrogacy-unfriendly state. That surprised me, so I looked it up and I found that we have this statute, and it says in Nebraska, surrogate contracts are unenforceable by courts. Upon looking into this more, I became interested in why Nebraska would have this law, so here's a quick history. The bill that created this law in 1988, LB674, was introduced by Senator Chambers. His intent was to prevent Nebraska courts from exercising jurisdiction over surrogacy contract disputes that might arise in a time when surrogacy was becoming more popular. I read some of his testimony, and in it, he noted that the bill does not make surrogacy contracts illegal. That is, it does not prevent people from choosing to make a surrogacy arrangement and abiding by the terms of that arrangement. But courts having the authority to enforce these contracts, he said, would result in stripping the rights of intended mothers. In bringing this bill, he came from the perspective of being a descendant of, as he put it, people who were bought, sold, and bred like livestock. And in the debate on this bill, he spoke to how being a descendant of slaves gives you a keen sensitivity to the commodification of human beings. Surrogate agencies, he warned, stood to profiteer off the exploitation of poor women of color who would never be able to have their own surrogates, while rich white women would always be able to. And he basically said this was a tool available to rich women to use poor women of color as breeders. I have an immense amount of respect for Senator Chambers, but I respectfully disagree with him here, though I honor that he came from a different position and a different set of circumstances, and that the world was also different when this bill was passed. I think he had some ideas about this bill that I don't agree with anymore in this present day, and I don't think that the law really holds up anymore. For example, Senator Chambers had a problem with surrogacy agreements in general, and his opinion, at least at the time, was that biological fathers ought to also be required to assume responsibility for the child they create via surrogacy. He also compared traditional surrogacy, in which a woman is impregnated directly with the gametes of the genetic father, to adultery, and said that couples unable to have children should adopt rather than arrange a surrogacy, which would commit adultery. I'm taking a different view on this because I think that it's not our role as lawmakers to bar Nebraska families from making choices that work best for them. And I think it's fair to leave any surrogacy dispute up to the courts. There have certainly been biases in our court system, but to render these surrogacy agreements legally null and void means that any couple or parent wanting to be involved in a surrogacy arrangement has no legal protection of their rights or enforcement mechanism if there is a disagreement. A lot has changed in the realm of surrogate parenthood since 1988. Surrogate parenthood is now used in many circumstances, such as major health issues of the mother, same-sex couples seeking to have children, individuals who want to be a parent, and couples struggling with infertility. The choice to be a surrogate or to use a surrogate for one's child is a deeply personal and emotional one. As with nearly everything significant we humans do, there are risks of emotional or physical complications. I think that we do Nebraskans a disservice by saying that any surrogacy arrangement has to be informal and on the honor system, and that there is no recourse if the intended parents and the biological parents don't agree on something. I will note that in my review of the history of Senator Chambers' bill, no one testified either in favor or against this bill, and no senator debated against the bill on the floor. So it seems like it was a personal passion of the senators and not something that arose out of constituent demand or test cases that showed it was necessary. A major problem with current statute is that courts will only grant parentage orders to genetic fathers, meaning the spouse or partner of that father has to complete an adoption in order to establish parental rights, whether or not they are genetically related to the child. So with LB89, we strike that statute that says surrogate contracts are void and unenforceable, and there's also a stricken provision in there that grants automatic parental rights to the biological father. That piece was included in the law because of Senator Chambers' view that if the child resulting from a surrogacy was somehow found unsatisfactory or was no longer wanted by either the intended parents or the biological parents, that someone ought to be responsible for providing for it, and he thought that should be the biological father. By striking the unenforceability of contracts provision, we cover for this circumstance by allowing couples to clearly outline the terms of what should happen in these situations beforehand in a legal contract. The Pew Charitable Trust did a review of state surrogate policies, and there are stories of surrogates who work with agencies being asked to sign contracts saying they won't go to a handful of states with these prohibitions, including Nebraska, because if a child is delivered here, it would be difficult to transfer custody to the intended parents. Many surrogates surveyed for the brief said that they want legal protections to ensure the intended parents take the baby, regardless of any birth defects or change in their own life situations. So this protection is beneficial for both the surrogate and the intended parents. There is an amendment on this bill, AM 203. I filed it in February. I brought this amendment after getting some feedback that I agreed with, that the bill should include some kind of protection for the health of the surrogate if a life-threatening situation arises. I heard examples where sticky situations came up mid-pregnancy, such as a woman who got a diagnosis of late-stage cancer and needed to start treatment as soon as possible to prolong and save her life. But this posed a threat to the pregnancy, and the intended parents threatened legal action if the woman were to seek cancer treatment, even though her life was at risk. With AM 203, the bill would say surrogates can't be legally held liable if they have to make choices about whether to receive medical treatment to protect their own health and safety. The language is borrowed from similar exemption in Texas's surrogacy law. I want to leave you with an excerpt from a Creighton Law Review paper that looked at the history of this policy and its impacts. It concludes, the unicameral should re-examine the social policy behind the law, especially considering the lack of debate in the law's passage and recent technological advances. Nebraska's law presumes complications that may not in fact exist and does not address surrogacy arrangements beyond those existing at the time Nebraska legislators passed the bill. The law review goes on to say that the unicameral should provide certainty for those entering surrogacy contracts, and that even a flat prohibition of surrogacy contracts with criminal penalties would provide more predictability than Nebraska's current scheme. Surrogacy contracts should be recognized to allow for individuals to create families in a way that makes the most sense to them. Those with medical conditions, those with infertility, those who are in the LGBTQ community deserve the opportunity to raise children if they want to. For some parents, surrogacy is the best opportunity to experience parenthood. There are many various pros and cons to why a family might choose surrogacy versus adoption, and I think Nebraskans should have that choice. LB89 with AM 203 would protect the rights of intended parents who are ready to start or grow their families while also protecting the life of the surrogate. Both are important. Thank you.
Any questions from the committee? Senator Decay.
Good afternoon, Senator Hunt. We say the baby's born, you have the surrogate and you have the parents that are going to have, and both of those parties decide they didn't want that baby after it came to earth. What are the protections for that baby going forward, and how would that be handled? Would that be handled through an adoption agency?
Well, what this bill would do is actually put more protections in place for that baby, because it would allow an enforceable contract that stipulates what the intended parents and the biological parents want to have happen should that be the case. As it stands today, I mean, the baby would just become a ward of the state immediately, basically, because any contract between them wouldn't be enforceable.
Thank you.
Any other questions from the committee? Seeing none.
Thank you.
Thank you.